Hi, my name is Nancy Mendez, and I'm the founder of Nancy D. Mendez Law. So here at Nancy D. Mendez Law, we do estate planning. So what exactly is estate planning? So estate planning avoids the probate process. So then what does probate mean? So probate happens when someone passes away without having an estate plan. When that happens, that person's family members or beneficiaries have to apply to the court for the permission to start administering that person's intestate estate. So when that happens, here in California, there's various costs associated with that. Number one are attorney's fees, which generally speaking are about 8 to 10% of the total value of the assets left behind. Then we have debtors. If there's any debtors, now they know exactly what you left behind because everything has to be administered with the court. So debtors also have the ability to say, hey, I want my bill paid before you administer anything. And finally, Medi-Cal. If Medi-Cal was used in the lifetime of that person, there are certain services that Medi-Cal can ask to be paid back. So when we do an estate plan, we avoid that process completely because then that person or you have left behind instructions on how you want your assets to be administered and, more importantly, the power to do that. So how do we do that? Now, generally speaking, there are 4 documents that create a complete estate plan. We have a trust, a will, a power of attorney, and a health care directive. So starting first with our trust, the easiest way to describe it is imagining that you open up a safety deposit box. And in this safety deposit box, you add all of your assets. So real property, instead of being in your name as an individual, it's going to be in the name of the trust. Same thing with life insurance policies. If there's any life insurance policies, that trust is going to be the beneficiary of that life insurance policy. So once you pass away, all of your assets are going to funnel into that trust and be administered pursuant to the instructions that you leave behind. So for example, if you say something like, I want my assets to be distributed to my children when they turn 25, that has to be respected because you wrote it when you were living, capacitated, and you left the power for your trustee to do that. So think about it like this. That trust is going to basically protect everything and give your trustee the power through that contract that you wrote to administer things the way that you left behind. So that's our trust, number 1. Now moving on to number 2 is our will. So with respect to the will only supports the trust. While the trust makes that safety deposit box, the will gives the power to that executor to execute something on behalf of the person that's passed away. So a good example might be, let's just say that you slip and fall at Target and you win a settlement check. And that settlement check comes in the mail, but you pass away before getting a chance to cash that settlement check. Now, if no one has the power to cash that check on your behalf as an individual, what do? Well, that's where that will takes into effect. Your executor now has the ability to execute that check on your behalf. So that's why the trust and the will work together. The trust to make that safety deposit box and the will to give somebody the power to act on behalf of that individual person. Now moving on to number 3, which is our power of attorney. The power of attorney is very similar to our will, but there's something crucial about it. It's only activated when you're living but incapacitated. So for example, if you have dementia, Alzheimer's, that power of attorney would be used to administer your estate while you're in that incapacity. Now once you pass away, it also passes away too. So then it would be your will that takes over after that. Finally, we have our number 4, our Health Care Directive. So this Health Care Directive works with respect to your final wishes once you're in that position of passing away. So if you want to donate your organs, if you want to be taken off life support, if there are certain medications that you don't want to have administered, all that is going to be written in your Health Care Directive. Think of it kind of as a power of attorney, but for your health. So these 4 documents, as you see, create all of that power and protection that allows your family members or loved ones to act on your behalf, respect your wishes, and have the power to say, okay, we have everything written down, your wishes will be respected. So it's always important to remember to have these documents done with an estate planning attorney. Notaries, document preparers, they don't have the legalities, the legal capacity, and the experience to do all of these documents that are so very important. So if you could take any advice from me, take this advice. Look for an attorney in your area that's able to do this. Now, if you're in California, I'm happy to help. So for more information, contact my office. I have locations in Oxnard, Bakersfield, and also the Monterey Peninsula. Happy to help.